The judiciary is one of the three co-equal arms of government besides the legislature and the executive. The judiciary is established under Article 159 of the Constitution of Kenya, and it derives its authority from the people of Kenya as the independent custodian of justice in the country, exercising its mandate to expeditiously administer justice to all irrespective of status, to administer justice without undue regard to procedural technicalities, to protect and promote the purpose and principles of the Constitution 2010, and to promote alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms. The courts in Kenya operate at two levels: superior and subordinate courts. Superior courts comprise the Supreme Court, Court of Appeal, High Court, Employment and Labor Relations Court, and the Environment and Land Court. Subordinate courts, on the other hand, include the Magistrates' Courts, Qadhi's Courts, Court-Martial, and any other court or tribunal established by an Act of Parliament. A magistrate's court has the authority to hear all criminal cases except murder, treason, and crimes under international criminal law. It has the authority to hear all civil cases except those limited by statute. Qadhi's courts have authority to hear cases on marriage, divorce, and inheritance where those involved are Muslims. The court-martial hears cases involving people serving in the military, and they are established under the Armed Forces Act. Tribunals are bodies established by Acts of Parliament to exercise judicial or quasi-judicial functions. They supplement ordinary courts in the administration of justice, but they do not have penal jurisdiction. The High Court has jurisdiction to hear all criminal and civil cases as well as appeals from the lower courts. The Court of Appeal hears cases arising from appeals over the decisions of the High Court as well as any other court or tribunal. Kenya's apex court, the Supreme Court, has exclusive original jurisdiction to hear and determine disputes relating to presidential elections arising under Article 140 of the Constitution. It has appellate jurisdiction to hear and determine appeals from the Court of Appeal and any other court or tribunal as prescribed by national legislation. It hears and determines matters involving the interpretation or application of the Constitution and matters of general public importance. The Supreme Court has the right to render advisory opinion at the request of the national government, any state organ, or any county government with respect to any matter concerning county government. It can also determine the validity of a declaration of a state of emergency, an extension of such declaration, or any legislation enacted in consequence of a declaration of a state of emergency. The 2010 Constitution of Kenya set the stage for an independent and transformative judiciary, which was a major departure from the judiciary of the past, which was widely viewed as an extension of the executive and was blamed for practices that did not meet the aspirations of Kenyans. Through the Judiciary Transformation Framework, or JTF, launched in 2012, the judiciary positioned itself as a strong institution geared towards world-class standards in service delivery. The JTF was anchored in four key pillars, namely a people-focused delivery of justice, a transformative leadership, organizational culture and professional staff, adequate financial resources and physical infrastructure, and harnessing technology as an enabler of justice. An organized court structure and a professional administration wing are now in place to deliver on the mission and vision envisaged in the transformation blueprint. The judiciary's professional capacity in administration ranks went a notch higher with the establishment of the Directorates of Human Resources and Administration, Finance, Supply Chain Management, Public Affairs and Communication, Accounts, Performance Management,